Good afternoon. Thank you for joining us today. Roughly 2 months ago in March, the DOJ, along with 15 AGs and the District of Columbia, filed an antitrust lawsuit against Apple, alleging that Apple's various policies regarding its iPhone violate the Sherman Act Section 2, specifically, obviously, monopolization and maintenance of monopoly power. So with that, joining us today, and I'll keep it brief so that we can get to the substance of the discussion, is Professor James Cooper from George Mason, Professor Erika Douglas from Temple University, Professor Thom Lambert from the University of Missouri. My name is John Yoon. I'm the moderator, and I'm also from George Mason. And so with that, let me start with Erika. Erika, could you, and it's a complicated case, so we want to give you a little time on this. Could you offer a brief but comprehensive overview of the case?
Thanks so much, John, for having us. For those who aren't familiar with the DOJ's case, I think it's important to situate it more broadly. It's part of a wave of antitrust litigation against large technology platforms that really reflects current reform efforts in antitrust law. And that wave began with the DOJ's case against Google for search practices, which had its closing arguments just last month. And then there's a DOJ case against Google for online advertising, and the Federal Trade Commission has cases against Facebook and now Amazon. So it's an exciting time to be studying antitrust and technology. There's also been private antitrust litigation, which we'll talk about today, against Apple in the Ninth Circuit about its App Store practices, and that overlaps in part with the DOJ's case. So in that sense, the bringing of this case is not a particular surprise, but it's significant nonetheless. All of these tech cases they're really the first bet the farm cases since US v. Microsoft in the late 1990s. And those cases that are happening now are particularly interesting with that context of Microsoft, as we'll talk about, because back in 1998, Apple was the upstart competitor. Apple was the one complaining to DOJ about Microsoft. Now Apple's the alleged monopolist. So the tables turn in tech. Let me turn to the contents of the Apple complaint. So as you mentioned, John, it was filed on March 21st in the District Court of New Jersey. So in my third circuit here, the case has been reassigned to Judge Julian Niels. The first judge recused himself. And the claims allege Section 2 Sherman Act violations by Apple, so monopolization claims, and then also state antitrust law claims in Wisconsin and New Jersey law. It's about 80 pages long, so for the complaint, so I'll give you the highlights. And I think the best way to understand it, and Tom will talk about this more, is the complaint is structured around sort of two different kicks at the can of market definition. The first being a performance smartphone market, and the other being a more general smartphone market. And then there's a monopolization claim, and in the alternative, an attempted monopolization claim in each of those markets. So really the center of the DOJ's argument is that Apple feared the disintermediation of its iPhone as a platform. So it engaged in this strategy of exclusionary conduct, using its power in the iPhone ecosystem to block innovation that threatened its dominance. And the argument pattern that plays out for 5 different technologies in the complaint is essentially different variations of this. Apple blocked innovation and access to that innovation for end users for technology that is cross-platform, meaning you can use it on any smartphone. It's hardware agnostic, because those technologies threaten to facilitate switching away from expensive iPhone hardware, which would disintermediate Apple and end its monopoly. And so there's different versions of this that are presented in the complaint. I'll talk about a couple of them because it's organized by technology, which I think is a little bit unusual. For 2 of the technologies, super apps and cloud gaming, the complaint is really saying Apple limited distribution and development of these sorts of technologies because they would work on any iPhone. And so they would be disadvantageous, or work on any smartphone, and so would be disadvantageous to iPhone. And so super apps, I'll explain that argument. These apps offer a lot of functionality in one. You can think of them a bit like a tiny operating system or a little app store in themselves. And if super apps became popular, the user wouldn't need an iPhone anymore. As long as the app was present on their device, they could access the same functionality through the super app. All you need is the super app. So DOJ is arguing Apple created rules on its App Store that tended to exclude those super apps, rules about how they could be displayed and marketed to consumers. Then similar arguments are made for cloud gaming regarding App Store rules and APIs. And that's really the first two technologies. And then there's a different sort of variation on the argument for the last three technologies in the complaint, but still really about Apple blocking middleware style innovation. And so the complaint for the last three technologies argues that Apple degraded user experiences at other access points through which alternative technologies, non-Apple technologies, might reach consumers and encourage switching away from iPhones. And I think the most familiar example for Android users is the allegation that Apple degraded cross-platform messaging with non-iPhone. So Apple Messaging is a popular service. When iPhone messengers send a message on iMessage to non-iPhone users, to say an Android user, the recipient gets a lower quality message, grainier photos, limited functionality, or unencrypted messages. And so that, the complaint argues, makes consumers more likely to stay on iPhone so they can enjoy full messaging services. And there's interesting different versions of that argument related to degrading access to third-party smartwatches, so making it more difficult to use a third-party smartwatch with an Apple phone, and then also a set of arguments that Apple limited innovation and access for digital wallets that are not Apple products. So in essence, the arguments really boil down to the concept of Apple competing not by making its phones better, but by blocking competing technologies and making them seem worse, and blocking innovation and features that consumers want to create this moat around iPhones. And we'll talk more about harm later, but the DOJ is arguing that this resulted in harm to consumers who are deprived of that innovation and also paid more in some instances for products. And I think a final interesting sort of twist in the complaint is it says this is a non-exhaustive list of technologies and anti-competitive acts that as technology advances, the technologies that are impaired by Apple and the manner of the impediment might shift. So that's pretty open-ended, but in broad strokes, that's the Department of Justice complaint right now. So let's discuss.
Thank you, Erika. Appreciate that overview. Thom, Erika mentioned these market definitions of, I think, smartphone and performance smartphone, and the market shares differ based on that, but they're all pretty high. My understanding it's based off of revenue instead of units. And that's always been a debate within agencies, and it would have been nice to have both. But that being said, what's your reaction, starting at market definition, to these relevant markets? What are the thresholds that you consider to be, alarming for monopolist type of power? And, what areas of the DOJ in this area, if any, do you think they'll have some hurdles overcoming?
Sure. Well, as you know, the offense of monopolization under Section 2 of the Sherman Act requires the possession of monopoly power in a properly defined market. And there are a couple of ways to establish monopoly power. The more common one is indirect evidence looking at market share. Courts typically require something in excess of 70%, but some courts have found a monopoly power on a lower market share threshold. The other way to show monopoly power is via direct evidence that the defendant can control market prices. And typically the way to do that is to show that the defendant charges prices that are greatly in excess of its incremental cost. So the complaint in this case takes both tacks. As you point out, John, it alleges a market share of greater than 65% in smartphones and greater than 70% in performance smartphones. And then it also contends that Apple earns profit margins that are much greater than its rivals. So that would be sort of direct evidence of monopoly power. So here are some hurdles I think that the Department of Justice is going to face on each of these attempts to establish monopoly power. First, with respect to the market share or indirect evidence of monopoly power, there's always the question of whether the market is properly defined. Does the market include all substitutes that are close enough to constrain a market participant's pricing? It seems to me in this case that with smartphones, probably that would be a broad enough market. The next closest substitute to a smartphone as the dumb phone is not nearly as close, and people would probably not switch to a dumb phone in response to a small but significant increase in the price of a smartphone. On the other hand, the performance smartphones is a little bit trickier. It's not exactly clear what they are. There's not a lot of detail on that in the complaint. And many people don't use near the capability of their smartphones. I happen to be one of those people. That phone does all sorts of things that I don't come close to utilizing, and yet I buy the expensive Apple phone. Those people would probably likely switch to a lower end phone in response to a significant price increase, but we're going to need some more fact finding on that. It doesn't strike me that performance smartphones is an implausible market definition. Now, turning from market definition, we get to the issue of market share. And as you point out, John, the market share here appears to be based on Apple's percent of total revenues and not Apple's percent of the total number of units shipped. And that might actually inflate the market share percentage a bit because Apple phones are more expensive than Android-based phones. And that's because Apple monetizes its mobile operating system by selling hardware. I mean, that's how it collects for its development of its mobile operating system. The phone price includes compensation for the operating system. Samsung and other smartphone manufacturers use the Android operating system, which they receive for free from Google. And Google, in turn, monetizes its mobile operating system, Android, by hoovering up a whole bunch of data from users and then using that data to serve ads. So effectively, the cash price for an Android phone doesn't include the full price that consumers pay. They also sacrifice some privacy when they buy an Android phone over an iPhone. And if we took account of that, then Apple's market share would look smaller. Now, that point, I think, also weakens the government's direct evidence of monopoly power. It's based on the fact that Apple earns significantly higher profit margins than its rivals. But when you account again for the incremental price that Android users are paying by giving up data, the difference in the price cost margin on a Samsung phone versus an iPhone is not as great as it might appear. One other thing to note on market definition, the DOJ defines the market as the US market because American consumers can't easily turn to foreign suppliers of smartphones. Outside the US, Apple is much, much smaller than Android. Apple's market share is much more smaller than Android's market share in the operating systems market. And in the hardware market, Samsung actually sells more phones than Apple does. Even if we define the market as the US market, I think that's a relevant fact because it seems to show that two highly sophisticated companies, powerful companies, are waiting in the wings. They dominate elsewhere, and they could dominate in the United States if Apple were to misstep by providing an offering that consumers don't find as valuable. One last thing to note here, a lower market share may not be all that important in this case. I mean, we're right on the threshold for what courts have found to constitute monopoly power. But remember that the government sued not only for monopolization, but also for attempted monopolization, which has a lower market power requirement. It doesn't require the possession of monopoly power. It requires a dangerous probability of attaining monopoly power. And courts have frequently focused on a market share that's not yet at monopoly levels, but is getting fairly close, but that's a lower market share threshold. So even if the government fails to establish monopoly power, they probably are going to be able to establish a sufficient market power to make out the power requirement of an attempted monopolization claim.
Thank you, Tom. Just to close the loop on market definition, James, Erika laid out some of the specific technologies that the complaint discusses cloud gaming, digital wallets, and all the litany of other areas. But the complaint also sort of neglects defining any markets around those areas of technology. Are those central to the complaint in terms of defining the market, or what's going on here? Why is that not really given a lot of attention?
Well, thanks, John. It's great to be here. Glad to be part of this, and good to see Thom and Erika, if at least virtually. To answer your question, one thing before I answer your question directly is another thing I'd want to maybe put on the table, or maybe just mention in the market definition, is the impact of the fact that DOJ does allege that Apple is a platform, and of course they use that to say that, well, by degrading some of these, they say that it's a profit sacrifice, but it also, in market definition, makes demand more elastic, because if you raise the price on one side of the platform, then you're sacrificing revenues on another side of the platform, right? So you have fewer. If I were defending this, that's another thing to take into account, is that leaving aside market shares, when you look at substitution, if I raise the price of my smartphone, then I'm going to lose customers, and therefore I'm going to lose revenue on the app side, and people will be less willing to, with indirect network effects and that. So I just wanted to throw that out there, as well as another consideration of market definition. But to answer your question, to get into, now I think as just a pure legal matter, DOJ does not need to define these markets, because they have alleged the harm is going to occur in the smartphone or performance smartphone market. I mean, that's is a legal matter. That's what they're going to have to be required to say this is the relevant market. I think that where they're alleging not necessarily a relevant market as a legal matter, and cloud gaming and super apps and smartwatch and digital wallets and the such, that is a result of Apple degrading the interoperability between that in these other products with the iOS platform, that this sort of harm, or this sort of degradation, is making the iOS platform more sticky, to use a term they use quite often in the complaint. And I think that this is relatively straightforward with, as Erika I think laid out great, this super app, a term I'd actually never heard until I read the complaint. But of course, I'm on the edge of being a boomer, so of course, why would I have heard of a super app? The super app seems that it's a little more Microsofty, in the sense that here's a way that I can, the same way that Microsoft was alleged to see the threat that the internet would pose, and so let me lock in app developers to make sure that they don't write Java, they only write for Windows. Same thing here is, the potential of whether it's gaming in the cloud, or whether it's having an app that would allow me to have the identical functionality with a $25 used Android, to again use an allegation in the complaint, or an example in the complaint, versus a $1,000 iPhone 15. That's potentially worrisome. That sort of makes sense, but where messaging also, I guess the theory there about stickiness, that I've got an iPhone, it's harder to use messaging isn't as good between an Android, but iMessage is not as good between an iPhone user and an Android user, so I'm going to give everyone in my family an iPhone. So again, maybe makes it a little more sticky, the green bubble shame, but where I think potentially concepts, again, not necessarily defining a market, but concepts of substitution may play a role in the theory of harm. One area is, for instance, the digital wallet. That the idea, I guess the theory there, and I still don't really understand how it makes an iPhone more sticky. The fact that if I could understand potentially a theory of harm if I'm Bank of America or I'm Citibank and I would like to have my own wallet and compete against Apple Wallet, but I can't because Apple won't let me on the platform. But they're not alleging harm in the digital wallet market. They're saying because the only digital wallet on iOS is Apple's wallet, that makes iOS more sticky. But it seems, again, as a consumer, I've got credit cards that I just need to tap. It's actually easier to use than if I think about the functionality. And then there's kind of this, it's really an empirical question is, do DOJ posits a world in the complaint in which consumers would love to have multiple banking apps so they don't need to share any data with Apple? I mean, perhaps that's a theory. It's really empirical what sort of substitution, but they're already sharing data with Apple. If they've set up an account, Apple's got your credit card information, or at least one credit card. Maybe they don't have all the other credit cards. And there's, on the flip side of that, there's the seamlessness. I have an Apple Wallet that has my debit card, 2 credit cards, and countless other identity type things, my airline tickets, et cetera. That's a lot easier than opening up a lot of different apps. Actually, something that they talk about in another context, that with the super apps, oh gosh, I have to sign into lots of different apps. A super app makes that seamless. And now they're saying, well, on the banking side, let's have it the other way. So there, I think the concepts of substitutability would be imported there. If you're thinking about a theory of harm, the final point I'll make in this with respect to your question is, I think about the other, the final other market, the smartwatch. I mean, who doesn't really know all of this going into Apple? I mean, this reminds me a little bit of the Kodak case from ages ago, where there was market power in the aftermarket because I bought a Kodak copier and now I'm stuck and I have to get Kodak proprietary parts. And there are lots of antitrust cases that kind of, and then the issue there is, did that create economic market power for a Section 2 case or a Section 1 case in the aftermarket? This is different because you're saying that this lock-in, I've got an Apple Watch, and now this Apple Watch isn't going to be functional if I go buy an Android phone, that creates market power in the primary market. The Kodak case was pretty widely criticized at the time, and I think there's a lot of economic theory and evidence that suggests that there are problems with that theory of aftermarket market power. But here, one of the issues is information. Okay, I buy something in the foremarket, and now I'm stuck buying printer cartridges or service, and I didn't know that going in, so the primary market price can't adjust. But who does not know when they buy an Apple Watch that it's not going to work with something else, or if I buy a Garmin watch, that it's not going to work as well with an iPhone. There's not I know this is not a CP case, but when you're talking about these sort of lock-in issues, there's always an element of information. And if consumers have full information, then the primary market price should adjust to reflect that. Okay, I bought into the Apple ecosystem, and now I realize that all these other ancillary products I buy with it are probably going to work much better with Apple than, and maybe not even at all with an Android system. But there's no allegation here that consumers don't know this. And I think I can't speak for all of us on the call, but I think it's pretty well known that you buy an Apple Watch, it works with your iPhone. You're not going to get it to work with your Android. So I think, again, some of the concepts of substitutability, if I were defending this case, I mean, I would certainly find, with the messaging and certainly with the banking and the smartwatch, that some of these concepts of market definition would maybe poke some holes into DOJ's theory of harm.
Thanks, James. And yes, I also learned about super apps, and I feel really cool saying that. Although I do wonder, the complaint does tout super apps as something that's virtuous for consumers. What if Meta is super apped their Facebook with Instagram, with WhatsApp and Messenger? I think minds would be blown and people would be super upset. So I don't even know if we really want super apps, but I get the point of the complaint. Let's move into the heart of the complaint, actually, and talk about the theories of harm and unpack a few of them. I know we have limited time, but they talk about profit sacrifice without talking about duty to deal, which I think everyone who's attending probably knows duty to deal, and we start to think of that when we hear profit sacrifice, but we don't see it in the complaint. The complaint also doesn't move into an explicit tying allegation. And so in some ways, I'm left asking what's going on. Is this a duty to deal case disguised as one, at least? And will Apple try to steer it in that way? So Thom, what do you think? Is that something that Apple will attempt to do? And if so, what's the scope of their protection in terms of the case law?
Sure. Well, as Erika explains, sort of the crux of the government's theory of harm is that Apple has used its power over its mobile operating system to sort of thwart the development of technologies that could reduce people's dependence on their iPhones. It's a little bit like a tying case in that the government is claiming that Apple is doing something in one market, the mobile operating systems market, that has an adverse competitive effect in a related market. And it's specifically, it's a little bit like the tying claim in the Microsoft case, where the claim was that Microsoft had impaired competition in the browser market in order to protect its monopoly position in the market for operating systems. Here, the idea is that Apple is impairing competition in these related markets that James was just discussing, because they could somehow, if there were vigorous competition and there were better offerings in those markets, it would reduce people's dependence on their iPhones. The case is not pled like a tying case at all. So I'd be really surprised if the government actually litigates it like that, but there are some similarities. At the end of the day, as you point out, John, this really does look like a unilateral refusal to deal case. Apple is denying potential rivals access to critical APIs, application programming interfaces. I think that's what that stands for. But features of its platform that it controls, and it's thereby making it hard for them to compete. DOJ very much does not want to litigate this case as a unilateral refusal to deal case. And the reason is that those are very difficult to win. The famous case in which a plaintiff prevailed in a unilateral refusal to deal claim was the Aspen skiing case. But in its Trinco decision, the Supreme Court noted that Aspen represents the outer boundary of Section 2 liability, and it emphasized some key features that were present in that case. One is a prior voluntary course of dealing between the defendant and the plaintiff. Another is that the defendant has dealt with others as the plaintiff wanted, basically is selling the thing that the plaintiff wants to buy. And then finally, that the defendant's failure to deal with the plaintiff sacrificed current profits, suggesting an intention to recoup that profit sacrifice by charging supra-competitive profits in the future. In the Apple complaint, as you point out, John, DOJ repeatedly emphasizes that Apple's design decisions reduce its current profit. So it repeatedly makes these profit sacrifice allegations that look like Aspen, but there's no prior course of dealing here. Under Trinco, that seems to be a problem, although there are courts, post-Trinco courts, lower courts, who have said that Trinco does not actually require that there be a prior voluntary course of dealing. The prior voluntary course of dealing indicates basically that, it would be profitable for us to engage in these transactions, and we're not doing it because we want to earn monopoly profits in the future. And so some courts have said, well, if you can show that, you don't really have to actually show a prior course of dealing. But Trinco suggests that you do need a prior course of dealing. So in any event, DOJ doesn't really want to litigate this as a unilateral refusal to deal case. On May 30th, DOJ submitted a letter that said the following. It said, this is in response to Apple's request for a pre-motion to dismiss conference. And DOJ wrote, Apple wrongly seeks to supplant the general standard with a refusal to deal framework that only applies to narrow situations. So what it says there is that what it's invoking is the general standard on unreasonably exclusionary conduct and not the narrower standard on unilateral refusals to deal. Well, that raises, of course, the question of what is that general standard? And this has been a huge question in antitrust jurisprudence. Like, what exactly does it mean to engage in unreasonably exclusionary conduct? A couple of possibilities here. One approach, which is what the Rita Hovenkamp treatise has taken, is that this is a matter of welfare effects balancing, that you want to balance the anti-competitive harms of challenged conduct against the pro-competitive benefits that can't be achieved in a substantially less restrictive manner. That if anti-competitive harms trump pro-competitive benefits that can't be achieved less restrictively, then you have unreasonably exclusionary conduct. Another proposed standard for unreasonably exclusionary conduct is the profit sacrifice test, or a better version of it is called the no economic sense test. The problem with the profit sacrifice test is it suggests that you have to have two phases, one phase of sacrifice and a later phase of recoupment. Scholars have said, you don't really need to have the two phases as long as you can show that the defendant is engaging in conduct that makes no economic sense, but for its ability or capability of reducing competition and allowing for super competitive profits, then you've got unreasonable exclusionary conduct. Courts, to my knowledge, haven't fully endorsed the no economic sense test, but it looks like DOJ is going to try it here. The welfare effects balancing test has been pretty commonly used in the courts. In the Microsoft case, famously used it. More recently, the Supreme Court endorsed it in the Alston NCAA versus Alston decision. So I assume that DOJ is just going to go in that direction and say, look, we're as the Supreme Court, or not the Supreme Court, it was the DC Circuit in the Microsoft case says, the means of illicit exclusion are myriad. There's lots of ways. And so we need a sort of generally applicable approach. Just calling something pigeonholing and requiring that you meet the tests of a particular type of conduct isn't sufficient. That's not a good way to think about this. This welfare effects balancing test is a better way to go. I expect that's how this will work out. But there's one important thing to note here. This is not a neo-Brandeisian case. The claim here is focused entirely on consumer welfare. And it was a little bit surprising to me, honestly, when I saw that. So I think, as you point out, John, that the action in this case will lie not on market definition, not on the power element, but on whether unreasonably exclusionary conduct has occurred.
Thank you, Tom, for really great insights and overview. Erika, I want to get your reaction to the core theory of harm that the complaint is alleging. Is this a tying case? And if it is, what are the elements that are required? Or is this really more of sort of this larger exclusionary pattern that in essence maintains the monopoly and keeps the switching costs high and doesn't allow users to easily move over to alternative platforms? What's the broader overview in your sort of reading of the complaint?
I think it's a good question, John, and I think Tom answered to a large extent the tying perspective, but this is the case where when you read the complaint, it's not clear if it's tying, if it's refusal to deal, if it's raising rivals' costs, and DOJ, as Tom said, in letters exchanged on the record, is pushing back on categorizing it as any one of those and saying what applies here is the law in Grinnell, which is unlawful monopoly maintenance, which is quite general. I think that's already causing problems in the case. The court is going to want to look to some sort of established Section 2 violation, and it's sort of none of them. But I think that there is sort of a sliver of a refusal to deal being laid out, and that's in the smartwatch allegations. So there is sort of a pattern of story over time where initially APIs that were for third-party smartwatches were allowed full functionality. Then the complaint says Apple introduced its own watch, and after that degraded the API functionality of third-party watches. So I think that's the closest you'll get to sort of the first category of a refusal to deal being laid out, but that's not what the DOJ seems to want to do. You could have fit this case into a tying pattern, right? A tying arrangement is just an agreement by a party to sell one product, but only on the condition that the buyer takes another product they don't want. So there are steps here that Apple is engaging in that look a bit like the technological tying in Microsoft, but to a much lesser degree. Right? Microsoft, the operating system, stopped working entirely if the products were untied. For Apple, that's not the case. It's just sort of a situation of lower rival quality being made to appear. So we could look through a tying case, and they could have made out a tying case, but they didn't. The DOJ does not set out a tying argument, even though it seems like it might work on the case and it's patterned on Microsoft. But the case is really about consumers not being able to get access to what they want, more so than being forced to take products that they don't want from Apple. So I think we could say it's not a closest analogy to any of those things. I think the closest analogy to what it is a self-preferencing case. That doesn't really exist in antitrust law, but it certainly exists as a theory floating around in digital regulatory discussions where a platform treats its own products more favorably than it treats the products of rivals. And so in that sense, even though it's consumer welfare anchored for the harm, it looks a little bit like it has some neo-Brandeisian character to the case, because what they're sort of talking about is fairness of access to these platforms for rivals. That's not a recognized antitrust theory of liability under Section 2 law, but DOJ seems to be sort of laying it out and hoping that some new theory will be accepted here.
Thank you, Erika. James, before we move on to privacy, which is how I kind of want to close today's discussion, I want to give you an opportunity to kind of comment on this notion of extraction versus extension and whether there's sort of the complaint possibly is falling into that fallacy. Part of it is because of the complexity of these platforms, and Samsung monetizes very different from Google or other Googles, but specifically to Apple. And so you already mentioned network effects and how that could play into it. So any thoughts on that?
Yeah, I mean, I think your point about, as you said, rent extraction versus market extension or market power extension is part of a bigger point that I see here. Again, one of the big efficiencies, and we'll talk about privacy in a minute. But it's the kind of bigger economic point about all the benefits that come from integration. The way, I mean, I think about framing this in some ways is this type of exclusionary conduct is fits into a broader raising rivals costs theory, perhaps, that where an upstream or integrated rival denies access or provides access on less favorable terms with some sort of input that you need. And the here, sort of the raising the cost of rivals is the reduced interoperability with the reduced interoperability with iOS for non-iOS products. But I think that the problem here, if this assumes the baseline for sort of non-competitive input access is the same one, but the same functionality as an integrated company, and that assumes away all the benefits of that we know as economists have that come along with integrating complements, especially in a setting of when there are indirect network effects. So clearly one of the biggest benefits, it's well known, and I also want to say, I probably am throwing around the term efficiencies, but I do want to make sure that when we talk about the functional integration of complements, we're not it creates efficiencies, but not in an antitrust sense that will have the harm and then we're going to weigh it on the other side of efficiencies. I mean, these are baked in because they're just artifacts of change incentives that come when you have common ownership of complements. So, and this shows up I mean, again, this is sort of well known in the economic literature. I mean, one of the most well known when you're internalizing is that this all comes from internalizing cross-platform externalities. It's sort of common ownership, and you're internalizing all these externalities. One is, the elimination of double marginalization. Okay, so Apple, of course, is going to provide inputs more cheaply to its integrated parts than it is, and not just inputs, but but you also get the reason that that's just an incentive that's baked in, but you also get because of reduced transaction costs, including fear of appropriation. And I think this goes to your point about investments, is you're going to get more efficient investments in native iOS apps than non-native, because you are going to internalize all the externalities from the investments. You don't have the problem with the appropriation of relationship-specific investments, right? And so you're just going to end up having you're just as an artifact of this integration of complements in a network setting, you're just going to have things working better. You're going to have iOS working better than non-iOS. I mean, and to me, it has to do with again, DOJ picking the wrong benchmark. I mean, paragraph 126 of the complaint says Apple faces less competition, not because it makes its product better, because it makes it worse, but because of all these benefits that come from integration. I think what DOJ is referring to as degradation is really measured against the wrong baseline. It's measured against the baseline of an integrated platform where all these benefits naturally flow. So it's not really reduced functionality. It's just saying a non-integrated, something that's non-integrated doesn't work as well as integrated, but that's why you integrate. And, you know, it's the wrong benchmark. And I think that it in some ways suffers from what we again know in economics as the nirvana fallacy, right? That a non-integrated app should work just as well as an integrated app, that all of these things should work just as well. And then that means it's degradation, but I think it assumes away all the natural inherent benefits that come from integrating complements in a network setting. It's clearly, you know, if we could get all these things at arm's length through contracts, we would. This is why we have integration of complements throughout in a lot of settings. And clearly this is the way that Apple think is best to run their business, and they have for ages, right? They're the vertically integrated from soup to nuts company, and that's how they see and I think it's that's one of the to me one of the core deficiencies and probably one of the harder things that the DOJ is going to have to overcome as they go forward in litigating this case.
Thanks, James. And I think you really do hit on a very important point about the full incentive to innovate in this space, because part of the complaint, it seems to be, is a litany of wouldn't it be better if we had the following? And in some way, it's not hard to agree with the complaint. Yeah, maybe that would be better. But in a sense, what incentive does Apple have to develop the technology if it really just kind of opens it up and allows others to expropriate the rents for themselves? And that sounds super selfish of Apple, but in a lot of ways, that's what you need to spend and risk all that resources. But that being said, let's move to privacy. And Erika, I know this is obviously a key area of your research is privacy and antitrust. Where do you see that intersection of privacy and antitrust in this case? Does it relate obviously to the pro-competitive justifications that Apple will most likely bring, like they did in the Epic case? Do you see something similar? And more importantly, maybe for me especially, but hopefully others listening, is how do we differentiate pretextual privacy arguments from sort of legitimate ones? I know that's a tough question and not easy to answer, but any insights would be really valuable.
Sure. Let me start with the Epic versus Apple case, which you mentioned, and then I'll talk a little bit about how courts and we might judge whether a privacy claim is pretextual. So I mentioned Epic versus Apple at the outset. It's a significant private claim that was recently decided in the Ninth Circuit. And so it was brought by a video game app developer Epic against Apple. And like the DOJ case, it challenges the App Store rules, although the Epic case focused a lot more on payment processing rules and DOJ focuses more on other types of rules. But the Epic case is important because it established law that's going to be relevant to Apple's arguments on pro-competitive justifications if the DOJ makes out its initial case that this is anti-competitive conduct, because Epic was the first appellate decision to recognize that when companies compete based on privacy, that can be a justification in antitrust law for their conduct. So we're not just talking about standalone privacy. We're not just saying privacy is good. In the Epic case, Apple successfully argued it made its App Store a closed environment to offer users like you and I a secure and private store experience. And that was one reason why people chose Apple phones over Android phones, which are thought to be less secure. So the important part for antitrust is that connection to competition. And the DOJ is already anticipating in the complaint that Apple is going to say a lot of these rules, which disadvantaged competitors, were implemented to ensure a private and secure online environment for iPhone users. And so Apple, I think in particular, is going to argue that for the lesser access it allowed for third-party smartphones and also for the challenged App Store rules. And DOJ is saying Apple's selective, okay? It makes things private when it's convenient, and when it benefits Apple, it doesn't make things private. I think that's a bit unfair to say you have to be a privacy maximalist in all aspects of your ecosystem. Otherwise, there's no justification for improved privacy in parts of the ecosystem. I think it makes more sense to look at each of the allegations contextually on their own. So like I said, it seems like for messaging, Apple has a bit more explaining to do as to why Android has to be treated differently for a privacy or security reason, whereas for smartphones and the App Store, there's perhaps a stronger claim premised on the Epic versus Apple recognition of this as a justification that what Apple did was permitted. I mean, Epic versus Apple is also interesting because Epic was successful at the first step. So in the rule of reason. So it showed that what Apple was doing was anti-competitive, and a lot of cases end before that. So in that sense, it's relevant as well, but it's not related to the non-App Store allegations in the DOJ case. And I think that one of the big questions here, which you put your finger on precisely, John, is how do we know if a company is claiming privacy as a pretextual justification, or if this is truly the reason for the conduct? And I think in some sense that's an old question, and in some sense it's a new one. So it's new because privacy hasn't really been claimed as a basis for competition in these sorts of Section 2 cases before. But it's old because courts have been figuring out, based on the facts, whether or not this is truly what was happening in this situation. And that's what the question is here. Was this really a privacy decision? And so the classic things like internal documents, what did Apple say about why it had these policies? Or how Apple treats privacy in other contexts. So there, the DOJ might have a stronger argument, will become relevant to assessing whether what Apple is saying about privacy is pretextual. I think that's a pretty tough job in some sense for the court, but the DOJ is already hinting in the complaint that Apple has said things about privacy that are not true when you look at their documents, but the documents aren't there. So we'll have to see what comes out in those documents. And I think a really interesting case in that regard is actually a Canadian one called TREB, Toronto Board of Real Estate. And in that case, the court just looked at the evidence. The defendant said, we made these exclusionary policies to protect user privacy, and there was the privacy of people selling their homes. But when you looked at their documents, privacy was nowhere to be found as the reason for the decision. It was excluding competitors was the reason for the decision in the internal documents. And there, TREB had interpreted its privacy policy much more leniently when it was in its favor. Not just engage in different conduct, but literally interpreted parts of the policy more favorably when it was in its interest, but not users. So I think that courts would be capable of doing this, but Antitrust is not necessarily an expert in assessing whether there's privacy veracity, sort of behind these sorts of claims. And that's competency that the court and others are going to have to develop to be able to adjudicate this sort of privacy pretext versus privacy justifications.
Thank you, Erika. And I like the importation of the Canadian case. That's solid. James, the complaint, I have to give the sentence, which kudos to the writer of this sentence. Apple wraps itself in a cloak of privacy, security, and consumer preferences to justify its anti-competitive conduct. Sort of similar question to what I asked Erika, given your background in both antitrust and privacy. Will it wrap itself in this cloak of privacy? Will it have good arguments? What's the role of vertical integration, which Apple will tout in telling its efficiency stories? How do you see this aspect of the case?
Yeah, well, I would agree. I would really echo almost everything that Erika said. I mean, I think that if I'm Apple, I will certainly use privacy and security as a justification. Again, with, as I just talked about, the idea that they're that in this sort of integrated whole. I mean, this is how I've decided to structure my company. Really, since again, since the beginning, Apple is notoriously brand conscious. They, you can make very strong arguments that if I don't lock down the App Store and have the pre-approval process, that inures to the Apple brand name. So if Apple is my understanding in the space is that malware and things like that are much less likely on an Apple phone than in an Android, and those are trade-offs that both Google and Apple make. I mean, I think broadly that the facts in this case kind of understand the point that I and actually you and I, John, have made in some other academic work that we've written on the intersection between privacy and antitrust, that that competition over privacy, to the extent that it occurs, is really about positioning in product space. Not so much that that there's this positive relationship between highly competitive markets give you tons of privacy and less competitive markets give you less privacy. It's that actually the amount of amount of privacy you provide is in and of itself kind of the positioning, and it's the idea because unlike say a car manufacturer, you make an EV and you charge $50,000 and then you have market power, you decide to degrade the battery so there's a lower less driving range, but you charge the same price. Well, clearly consumers are worse off and you're better off. There's markets are there's less welfare, but with privacy it's different. You degrade privacy. Let's say that you make the choice of the Android ecosystem. You decide, well, what am I going to do is give away the operating system and let there be just super cheap smartphones. I don't care because I'm going to make it up on search and through my ad network on the open web. Let's say Apple is Google being an advertising based. Apple decides I'm going to provide a lot more privacy, but my hardware is going to be really expensive because my monetization is going to be primarily through the hardware. I mean, clearly they make monetization through the App Store and things like that, but it's different. It's different than the car manufacturer, because if I decide to degrade my product by reducing privacy, by say taking more data, the only way I can monetize that is by doing something that, targeted ads, tailoring my website, more customization, selling the data to a data broker who will give me money, and then I will, and then they will sell that data to someone who will use it to target. So there's some welfare built into it on the other side, and in addition, the monetization I get from the data gets competed through, and then I'm allowed to. And then that's kind of the distinction between the free versus the pay, right? And that's what we see Android versus Apple. So I think that there to that extent, I think that there's a strong argument that this is what privacy over competition looks like. One aside I'll say, since we're on the topic, is that again, kind of a tension is that that DOJ talks a lot about, makes a lot about both cloud gaming and the super app. So basically, that's where everything's being done in the cloud, but that requires data leaving your phone, going up to the cloud to do this. Now, what I would say in the ad tech space, where say, for instance, Google with Privacy Sandbox and cookie deprecation, one of the things that they're doing is trying to put the auction and put everything on the browser, on the smartphone, so that data actually doesn't leave that. That's a privacy enhancing. So in some ways, DOJ is the idea that you don't have a lot of cloud gaming or say super apps or cloud computing. That's also very consistent with privacy. And in fact, again, in the ad space, where Google and others are kind of sort of moving to get away from cookies and provide more privacy, you're seeing the exact opposite. Let's put all the computing for the real-time auctions on the phone in the browser, so we don't take data into the cloud, and that's privacy preserving. So anyway, I'll kick it back to you. I know we don't have that much time left.
Thank you, James. That was really enjoyed hearing that insight. We probably have time for one more question to Thom, and then perhaps an audience question or two. We'll see. No promises. Thom, part of the complaint built on Microsoft. And so in a way, do you see parallels that the complaint obviously is making? And relatedly, are there any key differences that you see?
Yeah, absolutely. The government's very much trying to stress parallels between this case and the Microsoft case, and some do exist. A number of the claims in Microsoft were based on Microsoft's efforts to thwart technologies that could challenge its dominance in PC operating systems. And primarily, it sought to thwart the development of middleware technologies, Java and Netscape. The Apple complaint repeatedly characterizes the technologies at issue, those that Apple is purportedly thwarting, as middleware. Some of them don't really seem to fit the definition of middleware very well, but that's clearly what the government's trying to do. There are at least 4 differences, I think, between the Microsoft case and the Apple case on the middleware allegations. First of all, Apple has far less market power than Microsoft did. Microsoft's market share at the time of that case was about 95%. There were no significant competitors. Obviously, Android is a massive competitor to the Apple mobile operating system. Secondly, the means of impairing middleware in Microsoft versus this case are really different. In the Microsoft case, Microsoft foreclosed distribution of middleware products by entering into agreements with distributors. It pressured companies like Intel to refrain from working with Java or with Sun Microsystems to develop Java. It lied to developers about the capabilities of its own version of Java. In this case, all Apple is doing is declining to provide rivals with certain amenities that they'd like to have. It's not excluding rivals from anything other than from its own platform. Third, Microsoft didn't offer any pro-competitive justifications for most of the middleware claims in that case. And then the DC Circuit emphasizes this, that they just didn't give any sort of response. In this case, as Erika and James have just discussed, Apple has some very good pro-competitive arguments to make about privacy, security, et cetera. And then finally, I think the dominance-threatening impact of the middleware in the Microsoft case was much greater than the dominance-threatening impact here. I mean, Java really made Microsoft's rivals more attractive to consumers. The innovations that DOJ would like to see might make the iPhone's rivals marginally more attractive to consumers, but they don't seem like they would move market share all that much. So I think while there are some parallels between the two cases, there are some very significant differences.
Thanks, Thom and Erika and James. We have a few minutes, and so I see one question, which is more of a legal question. The odds that this goes to the Third Circuit, this is totally outside of my area. Does anyone have any commentary on circuit type of movement? I see none. I see no observations here. So
yes, how about that? Yes. No, I mean, go ahead, Thom. You'll have a more educated guess than me.
I mean, it's filed in the Third Circuit, right? It's filed in the District of New Jersey. That's the Third Circuit, right? So the question is, will there be an appeal? If that's the question, yes, undoubtedly.
Yeah.
I took it as also it's odd that it's filed in the Third Circuit. I think it's because of the New Jersey state claims or some other strategy that's not apparent to us, but at least there's some pretty unusual Third Circuit cases coming up in like the letters that are being exchanged. It's not the case you'd first think of to cite for an antitrust precedent.
I think that just my brief understanding of that, like, and I would defer, Thom, you and Erika teach antitrust, so you probably know more than, but I think there's some more favorable sort of monopoly broth type precedent in the Third Circuit that may that if I'm going to do a Section 2 claim case, maybe you figure that the Third Circuit has the best case law in that area, but I would defer to you experts on that.
There is a very sort of pro-plaintiff decision, in-bank decision from the Third Circuit called LePage's that involved bundle discounting, which is not an issue in this case, but there is some broad language in the LePage's case that could be helpful, I think, here.
Well, we're right at 1, and to respect everybody's time, including the panelists as well as our guests. Thanks, everyone, and I really appreciate you joining us today for this discussion on privacy and antitrust in the case. Thank you.